go ahead and get started with our event for lunch. Please feel free to continue with your desserts and coffee. It's a great pleasure for me to introduce our keynote, which is going to be a discussion between Judge Doug Ginsburg, who is a senior judge on the D.C. Circuit and a professor of law here at the Antonin Scalia Law School, and also Professor Philip Hamburger, who is at Columbia Law School. And the discussion will focus in part on Professor Hamburger's new paper on the administrative evasion of procedural rights, which you can find on the website. And I think with the wealth of knowledge and experience between them, I suspect the discussion may range beyond the contours of the paper. And they've also graciously agreed to answer some questions towards the end of the lunch, so we will leave some time for that. Please join me in welcoming our keynote speakers.
Thank you, Naomi. Well, just to clarify, since Professor Hamburger is our guest and he has contributed a paper for this event, this will be not a discussion among equals, but rather a more of an effort to bring out more of the paper and beyond that. So I will be looking to you for leadership.
Oh, okay.
And I'll begin by asking you this very basic question about the paper. You having talked about administrative law in the past as something that is unlawful, and indeed presenting that thesis here a year or two ago, I can't help but notice that the emphasis in this paper is on administrative power. And I'd ask you to elaborate on the distinction between the two.
Okay, that may be, is this too loud? Maybe a little bit. The distinction may be more rhetorical than anything else. In law schools, as we know, we get taught administrative law. When we write in the subject, we tend to talk about it, the academics tend to talk about it as administrative law. And the assumption is that this is a form of law, or at least that it's law-like. And that's part of a long tradition of trying to legitimize this thing, whatever it is. And I don't want to start with the assumption that it is actually lawful or law-like. In my book, I went through the process of letting people think it's a matter of law, but in the end reject that and say it's actually mere power. And that actually is more akin to my view. I don't think it's law. I think it is mere power.
And it's power because it is tethered by procedures?
No. It would be comforting to think that power is acceptable and lawful as long as it's confined in some way by due process. But as we all know from administrative due process, that process can be remarkably weak. And also one could have mere power that is unlawful and nonetheless limited. And much administrative power is very regulated and very limited. Rather, I think the Constitution has only two avenues for binding power, and one comes through the legislature and the other through the courts. We have acts of Congress, and then adjacent to those, the ratification of treaties that are binding in the manner of law. And we also have the acts of courts, the judgments of courts, and those are also binding. And what distinguishes, I think, judicial and legislative power is its capacity to impose legal obligation, either the obligation of a rule or an obligatory judgment. And in contrast, there's what Hamilton calls the mere force, the physical power of the United States, which is in the executive. So any mode of binding people, of imposing legal obligation, judicially or legislatively, that doesn't come through an act of Congress or an act of a court, seems to me a form of binding people outside of, not through law, but through some other mechanism, which I think is mere power.
You singled out one of my favorite rascals here for chiding, and that was Woodrow Wilson. Yeah. And if you could just tell us a little bit more about his role in this or maybe not transformation, but in this development.
Right. Yeah, Woodrow Wilson is the gift that keeps on giving. Yeah. One reads and one's astonished And you think, well, that's the worst of it. And you keep on reading, and there's just more. And I love reading other people on Woodrow Wilson because they reveal to me quotations that are even more scandalous than the ones I found. It's no end of pleasure. Yeah, right. So Woodrow Wilson's an interesting guy. He was actually unlike many of the other early progressive advocates of administrative power. Most of them went off to Germany, as you know. They studied in Berlin under people like Treitschke, the theorist of the Machtstaat. We know where that led. And they learned German. They studied in Germany and came back and brought back the ideas of Bismarckian Prussian administrative power. Woodrow Wilson didn't get to go to Germany. So he actually studied German on his own. And this explains actually some of his ideas because many of his lectures are actually translations of German treatises, and they're poor translations. So what you might think is originality, deviation from the German model, a guy called Professor Mewald pointed this out. These are actually just his mistranslations. Like many members of the knowledge class, he's somewhat horrified with the product of expanded suffrage. In the 1830s, there's a completion of a process whereby white men, that is, get to vote regardless of property qualifications. And at the end of the Civil War, blacks get to vote. And along the way, the Irish Catholic immigrants get to vote, and some Germans and the rest. And all of this seems very liberal and appealing, but the results are rather rambunctious and sometimes violent, especially in New York and Philadelphia. And the genteel classes don't like that. And so they turn to German ideas of administrative power. At one point, Wilson said, this is more or less an exact quote, Wilson says, it's very difficult for the reformer to persuade the Germans, Irishmen, and Negroes whose brains have been warmed in different climes and then come over here. They don't vote in the same way, are not as easy to persuade as the Americans of the older stock. You get the idea. So yes, he's extraordinarily candid, and later writers do this all in much more coded ways.
I really opened the tap here with you. I didn't realize that he had taken bad ideas and then made them worse by mistranslation.
He's a talented man.
A large portion of this paper is devoted to the absence of a right to a jury in an administrative adjudication. And I realize that you also attend to some other procedures that are absent in administrative adjudication. But is it fair to say that is the central difference?
I would say the two key rights I focus on simply because they're so clear and and because they cut across the civil procedural divide, so that for purposes of the paper I don't have to distinguish between civil and criminal, what should have been civil or criminal proceedings, would be the right to a jury and due process. And both of these, I think, traditionally were understood to preclude administrative proceedings.
Now, when you use the phrase due process, I think your definition in the paper is quite specific and a little different than I would have, narrower, I think, than I would have said. But I'm not sure that everyone shares that. Can you just explain it?
So, and I don't want to take a position on exactly what outer boundary we should have to due process. I'm happy to have an expansive understanding of these procedural due process. But the historic core of due process, the bare minimum that it at least included, was what we call legal process. Original process, calling someone into a judicial proceeding, mean process, the intermediate process, subpoenas and discovery if you want, then final process, a writ of execution and the like. And this could only come from a court. And this is profoundly important because it means that you can't have adjudication outside the courts. And this was well understood. If I may just, with a little quotation, quote Houston George Tucker, who gives very early law lectures on the Bill of Rights. This is what he says in 1796, and even earlier, something like this. He said, due process of law, he quotes the Fifth Amendment's due process clause and then says, due process of law must then be had before a judicial court or a judicial magistrate. This is what he's teaching students at William and Mary in the 1790s. And James Kent says more or less the same thing. Due process of law means law in its regular course of administration through courts of law. Joseph Story as well. The point is that due process, although it may set standards, it does set standards for adjudication in the courts, its traditional function from the 14th century up through the 19th century is to bar adjudication outside the courts, to make courts the only avenue of binding adjudication. And after that, of course, it means more. It requires fairness and the like to some degree, but that's the basic core that we've forgotten is that it's meant to bar other sorts of adjudication.
That bar was broken, I guess, quite early, wasn't it? In the constitutional history?
It depends what you think is within the realm of binding adjudication. So if you're thinking of, which cases are you thinking of,
well,
for example?
Just the advent of the Commerce Act in 1886 or 7
Right, yeah.
would be
That's right.
a major milestone, I think.
Yes, that's right. That's the first major federal administrative agency. That's right. It's the beginning of the end, if you wish. But it took a long time. The administrative power, I don't think, provokes the sort of response it does today, because for a long time we could just view this as an exception. We generally are governed through law and through the courts of law, and that there's things on the margin that get administrative process, and we can live with that. In any case, it's just corporations that get bound, not individuals. And now that's all changed. Now this is the primary motive by which government interacts with us. And the American theorists who studied in Germany understood exactly what this means. The Germans had a theory that all government interaction with people, with citizens, is the same as a military order. So Goodenow says, look, everything is administrative power. There's a military order and there's a civil administrative rule. It's all the same. And that's actually now happened to us. We are now an ordered society. And the development of notions of Ordnung are now very applicable to us, unfortunately.
You attributed the location of the due process clause in the Fifth Amendment to an intention to, rather than putting it into Article 3, as an intention to make it applicable across the length and breadth of the government and not just in the courts. My understanding had been that the same decision was made with regard, as it was obviously, to all of the amendments, and that was preferable to rewriting basically the original document, and not because of an intention of the sort that you're ascribing here.
Right, so we don't have much of their commentary as to why they did this. We can only make guesses in retrospect. Certainly it's much cleaner to put it at the end. But the reality is they initially proposed actually altering the language within the Constitution, and it's interesting how they did this. The First Amendment, which contains the bulk of the substantive rights in the Constitution, certainly the ones that are most important, begins, Congress shall make no law. The rest, much of the rest of the Bill of Rights, and especially the procedural rights, are almost entirely put in the passive voice. So it's not Congress shall not do this or the court shall not do this. All of government is restrained, and the placement of the Bill of Rights at the end seems to work with that. If you had simply put the procedural rights in Article 3, they would not have limited the other parts of government. And so it seems to me consistent with the passive voice to have all of these at the end. They thereby limit all parts of government, and that confirms we know substantively of these rights, particularly the right to a jury and due process, that they were understood to bar administrative proceedings. So at least there's a consistency, even if we don't know their intent. That's right.
You seem, for the most part, to be critical of, but later on to redeem a little bit, Goldberg against Kelly and Matthews against Eldridge, which basically import a sort of cost-benefit analysis or proportionality requiring as much process as the stakes might warrant. Why isn't that a perfectly sensible way in which to apportion resources, both those of the government and of the litigants, so that we don't have jury trials over minor matters, let's say.
Right.
Every benefit termination.
Right. Arguments of efficiency, I think, are necessarily incompatible with claims of rights, especially procedural rights. So it may cost a little more, but I don't want to bow to that too quickly. And I think the results of these cases back this up. We're told that, at least I was told when I took procedure with Owen Fiss, that we have expanded access to due process because of Goldberg versus Kelly. And we spent, I think, 3 weeks studying
You
it.
told me that too.
And Matthews seems to confirm that. And certainly in a world in which government benefits are so important to so many people, there may be something to be said for giving some degree of process, even if it is not much, for the termination of rights. I don't want to dispute that, but problems arise with this. For one thing, it's not really much process one gets. One gets the right to a hearing in Goldberg. But of course, this right is often a hearing in which you can't be heard in the administrative state. And in most instances, of course, you don't have a right to hearing, and that's the process that's due. So I hope I'll be forgiven if I'm not terribly satisfied with this. It's like being given bread instead of cake. But it gets worse than that. And because the real danger is that these are benefits cases. So we get a smidgen of extra process in benefits cases where there is otherwise no due process right. But this has been part of a larger justification of denying due process in the courts of law in constraints cases, which is where one most desperately needs these. The academic justification for Goldberg is there's no difference between benefits and constraints for due process purposes. I think that's nonsense because, of course, when you're constrained, when you're imprisoned, whatever, you actually may want a little more process. And so I think that's just that blurring of lines an academic illusion.
Well, are there any administrative adjudications that lead to jail?
Yeah, well, my favorite case on this is the Hamdi case. So here's Hamdi. He did something at best
He was actually detained before this.
Right. No, he was detained for 3 years, and they just locked him up. And finally, he gets his day in court. And what does the Supreme Court say? They cite Matthews, and they say, you get basically an administrative determination, a fair administrative determination of whether or not you're an enemy combatant, and then you stay simply locked up. You never get your right to trial. Now, someone like that traditionally would have had a right to trial. He's either tried for treason and found guilty, or he goes free. He's a citizen of the United States. And I think this illustrates the profound dangers of Matthews and Goldberg. It justifies the most severe constraints on a sheer administrative detention. And we're now back in Prussia.
A lot of concern along these lines arose, I think it was out of newspaper articles, I think out of the Wall Street Journal articles about administrative law judges at the Securities and Exchange Commission. The report being that the commission had historically sent only very simple cases to ALJs, broker license revocations, and the only question was, had the broker done what was charged? And then started sending cases involving more difficult legal questions and complex cases to the ALJs, where they sort of a home court advantage. And indeed, the statistics bore that out. And you certainly pile on with respect to the inadequacy of ALJs. Why don't you give us the core of that?
Okay, right. So one of the standard justifications of administrative adjudication is, well, gee, it's fair. We have ALJs. Of course, as has been pointed out this afternoon, there's a lot of adjudication that is not done with ALJs, but let's just take the prototypical example of the ALJs. And I'm sure most of them are very conscientious and unbiased, although there's one at the SEC who seems determined to prove otherwise. Even the SEC asked him for an affidavit that he wasn't biased, and he refused to sign it. He's never held against the SEC. So the SEC astonishingly has made itself a beautiful illustration of some of the dangers. I never would have guessed it. The ALJs, one ALJ, McEwen, actually complained that she'd been threatened by the commissioners. complained about that the burdens of proof and persuasion were the reverse of what they should be. You're presumed guilty, and so forth. That's just one agency, and it's hard to generalize too far from that. But the interesting thing is, suppose we assume actually this is just an aberrant thing at the SEC, and most agencies are just utterly pure on the subject. ALJs are still profoundly problematic because on the questions that come up in every single case, they are pre-committed to the government and therefore lack independence and are prejudiced. They have protection for their salary and their tenure, but that's conditional on their meeting the requirement that they uphold agency rules. They are not authorized to question agency rules for being contrary to statute or the Constitution. And the constitutional questions run in all of these cases. So they are biased on the central questions you might want to litigate in every case.
Well, they won't reach those constitutional questions, but what about the commission itself when one appeals?
Could, but when you get to the heads of agencies, the independence disappears, doesn't it? These are political appointees. And of course, they get to review or finalize decisions of ALJs in many instances, in which case one can't even take much confidence in ALJ opinions.
Well, ultimately, everything can find its way into court. And in the case of most of the administrative decisions from the major agencies, they go directly to the Court of Appeals, with some exceptions. For instance, in the Clean Air Act, there's some provisions that go to the district court, but most of the decisions or at least the regulations, are reviewable in the Court of Appeals. Why is that not sufficient?
Right. So one might think due process and juries, it's all just delayed, and you get them when you get to court. Of course, these are rights in the first instance, not later, and some of the earliest American constitutional cases actually hold this quite clearly from the 1780s in the States. But let's forget that. Suppose at least we're content with due process and juries in the second instance. But of course, as you were suggesting, that actually doesn't happen. You're not going to get a jury in a court of appeal. And so there's deference to the administrative record. In other words, where the government's a party to a case, it's deference to the version of the facts presented by one of the parties. And so too in questions of law, whether Auer, Mead Skidmore, Chevron, all these rules of deference or respect give an advantage to one of the parties where the government is a party to the case. And this is actually quite astonishing because it means that on neither law or on neither questions of fact nor on questions of law do you actually get an unbiased decision in the courts. And this leads to a question as to several questions. One is, how do we view things like Chevron? And traditionally, the answer is it's a separation of powers question. But I'd suggest actually it's a question of due process. Chevron and similar such doctrines, whether about law or fact, all these deference doctrines actually deny one due process because it requires institutionally judges to be pre-committed to the position of one of the parties to a substantial degree. And that gets to a larger question about the role of the courts. Without commenting on any particular judge, it seems to me the courts as an institution, in bending over backwards to accommodate administrative power, I think have corrupted the judiciary. I think our entire judicial system has been corrupted to the bone, not because of any misconduct by any judge, but because the precedents requiring deference on law and facts mean that you really have no recourse to the courts. The courts occasionally will overturn them, but in most instances, why bother appealing?
So we come back repeatedly to juries. That seems to be the central
Certainly
thing.
a central point, yeah.
Do you go so far as Professor Suja Thomas in her recent book, The Missing American Jury, in saying that not only must every matter come before a jury, it's not something that can be waived by the defendant or by the respondent. Every matter comes before a jury, and if the judge thinks that the jury has erred substantially, it doesn't have the ability to enter a contrary judgment, but rather to vacate it and have yet another jury convened.
So I think I may disagree a little bit with that.
Now this is hers
Right.
is based on an originalist analysis.
And as is mine. So I guess we originalists disagree.
You sort of backed off of that in the beginning of the paper,
Okay.
right?
Oh, right. So the paper carefully is not originalist.
Yeah.
But I'm quite happy to defend my views on originalist grounds.
But they're different from hers.
Yeah.
Okay.
So due process, I don't think is something one can waive. If one wants to impose inquisitorial proceedings, if the parties agreed to it, I'm not sure the judges should indulge themselves in that. Perhaps the parties can go to a private adjudicator and settle this in some sort of private way, in that manner. Juries are more complicated because they're never. The imposition of juries beginning in 1215 after the Fourth Lateran Council was always taken in England in a complicated way. The government couldn't force you to take a jury, to accept a jury, and so the parties had to choose this. They'd have to declare, I want to be tried by God and my country, by a jury, and otherwise they had a right to the ordeals. And to force people...
Let's bring that back.
Yes. Wouldn't that be jolly? And the SEC would be delighted. But in any, I don't want to bore you with the entire history of the jury, but juries, I do not think, are quite the same. It always was optional. And so I want to be tentative about this, but I'm not sure I agree with Sujit Thomas on that. However, if a party wants a jury, I don't think, and you're outside equity and admiralty, I don't think the government has any choice but to allow you a jury. So there's mostly overlap with Professor Thomas.
You toward the end of the paper, you talk about the government bringing actions to restrain speech and press in agency proceedings.
Yeah.
What's a good example of that?
Right. Unfortunately, there are so many these days. The administrative state has become a way not only of evading procedural rights, most of the procedural rights we have in the Constitution, but also of undermining substantive rights. And think of the core of free speech in the press. It's not limited to a freedom from licensing, but that was the historic core. And that is no longer true. The Federal Communications Commission licenses words, and I'm mostly talking about licensing of words when broadcasting. The Federal Election Commission does this through advisory opinions. It's people seek advisory opinions that their speech will be okay, and then they get them. And this is a major mode of regulation now for political speech, core political speech. The 501c3 actually gives the IRS a licensing power over speakers and at least over what's they'll be expected to say based on prior examples of what they've published or said. And the example that got me into all of this actually is licensing of academic speech. How many of you have ever heard of an IRB? Right? See, most people don't even know, at least some of you, most people don't even know about the extent of censorship in academia. If I want to talk to any one of you in order to do academic research and perhaps publish it, I have to get prior permission from an institutional review board. I have to get permission for each question I ask. I will be forbidden from asking questions that will cause you emotional stress or financial harm. For someone such as myself, by the way, who studies the Ku Klux Klan, I don't really worry about causing emotional, legal, or social stress when I ask questions. But I can't ask questions. I can't ask government officials questions because they'll be protected. So this seems to me some concern.
I guess I'm in violation. I haven't submitted anything to an institutional review board. Is this a pathology of Columbia Law School?
No, sadly, it's research institutions that receive any federal money, which means all of them. Unfortunately, they're only beginning to touch law schools, but they're going for law schools increasingly.
Apart from the article you've written here, you have a piece that perhaps fewer people have seen, fewer people here today, that appeared in Real Clear Policy, called on administrative power, and there was a section called "What is to be done."
Right.
So to the Finland station, you asked the question, "What should a president do about administrative power?" And this was written in October before the most recent election, and you say, among other things, he or she, as it then was, he could require some agencies to send their existing and proposed rules to Congress for enactment. And how does that respond to this concern?
Right. So currently, we seem to be leaving all this to Congress, and I've never had that much confidence that Congress is going to solve this problem. And it also requires Congress. Typically, Congress would expect to deal with this in a sort of sweeping way across agencies. And in contrast, I think what the executive could do is take modest, cautious steps. If they take some small agency with rules that haven't changed that much and just ask the agency to send their rules to Congress to be approved and turned into a statute by Congress. And then if the sky doesn't fall, then try another agency. We're going to do it step by step, and we'll learn through the process. And that way one could moderately, cautiously start moving rules into the statute book and limiting agencies from adding rules without going back to Congress. That's the hope.
Where is the tea tasting board when we need them?
Right, Gary Lawson again.
And then you have require agencies to refrain from asking courts for deference on any question, whether a fact or law.
Right, so maybe the courts will deal with the deference problem. I can only hope. Because if it is a question of bias, it's a serious, serious problem and undermines the legitimacy of the courts. But the executive also has an opportunity here. The president could ask, or the AG could ask government lawyers not to seek deference in cases in which the government's a party, on the ground that government lawyers should not be participating in asking courts to exhibit bias towards the other party. That might be a due process violation of the government lawyers themselves, or an ethics problem.
There are a host of other suggestions here. I commend the article to everyone.
Right.
I wanted to reserve some time for, we have about 6 minutes for questions, but I'll take a few seconds before that to say that if I seem skeptical here, it's only because of self-discipline. Professor Stephen Menashe, my colleague here, and I recently have an article out called Our Illiberal Administrative Law, which is sympathetic to virtually all the points that are made here, although we don't deal with jury questions to any degree, significant degree.
I must say, I wish I could ask you questions, but you wouldn't be allowed to answer them.
But there are other aspects of this. I mean, the presumption of good faith, the presumption of regularity. It's not at all clear why the government should be indulged in those respects. Let's take some questions. Thomas, right there in the center.
I'll try to make this. My name's Elaine Middleman. I'm an attorney in the real world. When you talk about, I have two separate questions. I'll try to make them quick. But when you talk about jury trials, this is administrative law, but I do criminal appeals, and I think like 95% or 98% of the cases are a plea bargain. And if you try to go to trial and found guilty, then your sentence is dramatically increased because you didn't accept responsibility by not pleading guilty. So the idea of a jury trial in criminal cases is like a white elephant, essentially. And then in the constitutional due process, it's a totally different question. The federal people trying to bring a case for violation of their constitutional rights have to sue under Bivens, which the courts don't like Bivens and don't want to create any new causes of action under Bivens. But for state and municipal, you can go directly to court under Section 1983. And like for employee speech, it creates an entirely different structure. The federal have to go to, under statutory protection, not constitutional protection. And so I think there's a gigantic due process problem there also.
Yeah, I think those are both very, very thoughtful points. I'm not arguing against plea bargaining. I think obviously there are great dangers in the plea bargaining system we have, and I'm very much aware of that. But this argument does not deal with that. That's not an administrative power problem. It's a more complex problem, actually, isn't it? And I'm not sure that actually making juries available would, in the long term, mean more jury trials, as you suggested. But it would mean that the parties who do need to go before a jury because the alternative is worse, because not in all cases is the jury the worst alternative, at least would be able to do so. And ultimately, I think this would be valuable for the legal system because, as J.H. Baker has pointed out, he's a historian of English law, juries serve an important function in ensuring the clarity of our law and maintaining the distinction between fact and law. If it's in England, you abolish civil juries, you end up getting a very complex law that doesn't distinguish fact and law, and then it's very unpredictable, and you don't really know where to turn to find out what you should do in the next case. So actually, I think maintaining juries, even if there is some added expense, will have an enormously clarifying effect that will be very, very useful. The second question, remind me, was on, what was the second question you had?
It was about under federal complaints,
Oh, yes,
you
right.
have to do Bivens, which is you have to basically ask the court permission.
Right.
Whereas if state and municipal, First Amendment or Fifth Amendment
Right.
claims, you can go directly to court, no administrative proceeding, just go under 1983.
Right. So I have a lot to say that I won't share with you now about how this stuff should be litigated, but one of the clearest things in my mind is that not everything has to be sent to the Supreme Court or even to a federal court. There are many angles on this for purposes of litigation that will come in complex and unexpected ways. And there is a problem, I think, in not being able to bring some of these suits at the federal level. Ultimately, this gets to questions of qualified immunity, which is another one of my suggestions. I think there are some agencies that are begging to have their officers lose qualified immunity. We can do it agency by agency.
Last time I asked, which was this morning when I asked Siri, the Seventh Amendment had not been incorporated against the states. Boyden?
Just really more an observation about First Amendment rights. I think it's true under the orderly liquidation authority of Title II of Dodd-Frank that appellate rights are severely limited. But if you leak to the press that this is going on, you go to jail. I mean, it's a criminal violation if you go public with it.
Can I just follow up on this? So there's a free speech aspect on a lot of these questions that I think needs to be litigated very soon. I hope to do that if you don't. So, but between the two of us, someone should.
But
one example, just to throw out one that has remained dormant for well over 50 or 70 years. When an attorney general of a state under a blue sky law or an executive act or the Martin Act, such as we have in New York, sends a subpoena, an investigative subpoena that could lead to civil or criminal charges later, the subpoena almost invariably will include a clause saying, by the way, you can't talk to anyone about this. Now, notice these are not national security cases where already it's a curious question. And it leads to a question of how can you defend yourself and your constitutional rights if you cannot find similarly situated defendants? This is a pretty serious free speech and civil liberties question. And this is begging to be litigated. We just have to find the right plaintiff.
Bill, right here.
Bill, what about the states? Is the due process clause there going to do the same thing to state administrative agencies, or will you distinguish the due process clause, the 14th, from the 5th, as Gary does?
Right. That was an elegant attempt on his part. I don't see a difference between the two. However, I'm fairly skeptical about incorporation both as a matter of originalism and as a matter of policy. I don't want to bore you all with my thoughts on this, but the evidence of incorporation historically is remarkably low. And if you really want to find out how incorporation happened in this country, you're not going to be reading Supreme Court cases or congressional debates. What you have to read are nativist tracts, anti-Catholic tracts, including Ku Klux Klan literature. And then you can see where incorporation really came from. So there's a nasty history there that we don't always want to see. Now, a state due process provision, I think, can get you quite far, but it depends on the state. So, for example, the state of Virginia, just to mention something really rather quirky, the state, since we're here, the state of Virginia once distinguished itself by having two separation of powers provisions in the Constitution. And then in 1971, what did it add? Because it had, the tripartite system of government, it added an administrative power clause. So it has three parts of government. So in Virginia, I'm not sure that anything will help, but who knows?
What about the 14th Amendment? Would that stop would that require jury trials for state?
If we have incorporation, that's an interesting question. That's right. Maybe it would. maybe the court will back away from incorporation then. I don't know.
David there.
So, Philip, the due process clause has always been concerned with the arbitrariness of government action. And I'm concerned that adding juries, not in a theoretical way, but the actual juries that we use in practice today, which are 12 random people who have no prior experience or knowledge of what they're doing in a particular case, will actually lead to incredibly arbitrary decision making. They don't write opinions, and they're not repeat players and so forth, and actually will make it very difficult to know in any given case what your rights or responsibilities are likely to be, because the jury is kind of a black box, and in some ways be a lot less arbitrary to require written ALJ opinions that are precedential, so at least in advance you have some idea of what the likelihood of the adjudicatory result will be.
Right. That's an interesting problem, isn't it? So a large part of administrative law is justified on theories of rationality, rational analysis, the process, not as it were, the due process of the mind. And in contrast, traditional common law visions of adjudication have to do with divisions of authority between judge and jury, between legislature and the courts, and so forth. And so we have quite a radical choice here between processes that divide authority and sort of the mental processes. And the mental processes are very appealing to us as academics. But I'm not sure that the unexplained just divisions of authority that were traditional common law are really quite so irrational. The traditional division between law and fact is the division between that which judges can discern with some clarity and that which may be too complicated to reduce to words, to a rule. And I might add that juries are remarkably useful for the reasons I suggested earlier, because ultimately it's not just the case we worry about, but the law we have. And only by having juries do we maintain judicial opinions that distinguish law and fact and that state the law in a way that can be explained to 12 very ordinary people. And if you want to put it politically, just to move to another level, there'll be increasing number of cases as we have ever more government participation in private affairs in our country, increasing number of cases where if you think of all the people who could decide your case, the last people you want to have decided are government officials.
In a complex case, you don't have any objection to a special verdict, do you?
No, but it's interesting. The founders discussed this. Originally, they leave the civil jury out of the Constitution because they look to Mansfield and Holt, and they think we might want to have these complex jurors who are chosen for property and commercial qualifications. And the anti-federalists go ballistic, and the federalists cave in on this, and so it's with full knowledge of the inconveniences that we end up having a guarantee of a civil jury. I don't think this is actually an impediment to commerce, because the reality is, as Lisa Bernstein's work shows, our industry has a remarkable capacity to hive off certain types of cases and put them into private dispute resolution, sometimes which is far more sophisticated than what happens in the courts, and also doesn't have to deal with things like the UCC, which is so dreadfully drafted. So who knows? There may be multiple benefits.
Naomi, do we have time for one more? One more, okay. Open it up. Back there.
So one of the panels earlier today thought of procedural constraints as just slowing and mucking the process all down. And I guess one of my questions is, to what extent do you think, requiring juries would end up slowing down, say, the entire process? And to what extent is that actually a good function, bad function, what have you?
Right, so this depends very much on the efficiency of the courts and how quickly we have juries. One of the curious things that's happened over the past century is that we have deprived ourselves of juries in a vast number of cases where the government's acting against us, precisely the situations which you really might politically want to have a jury, and at the same time have hyped up the requirements of due process so that they're so expensive that only the wealthy can afford them. I don't think this is entirely an accident. Roscoe Pound, I think, was clued into this very, very early on. And perhaps we'll have to, it may be necessary to consider what is the due process and the style of jury that we want. I think the constitutional requirement is not such that it requires a jury that can only be afforded by the very wealthy in a remarkably sophisticated and well-to-do society. There's a range of possibilities that I think are perfectly constitutional.
Well, I haven't gone and deferred to the government yet all day. I've got to go do that. We'll call this to an end, and thank you very much.
Thank you so
for
much.
making it.
Thank you. It was very funny.